Welcome to episode 64 of the Cashflow Connections podcast. The topic for today is why should you consider using Wyoming for your next LLC? You see, not only does each state have different laws governing things like what you can and can't do, there can be some pretty significant differences regarding the amount of asset protection entities in different states can offer. For example, have you ever noticed that a lot of the syndications out there typically use Delaware LLCs? Have you ever thought about why this is? Because obviously most people aren't operating their business out of Delaware. Well, it's about the asset protection. Well, our guest thinks Delaware is a really good option. He also really likes Nevada, but from his perspective, Wyoming is actually his favorite for a variety of reasons. Asset protection is one. Also, the low cost of maintaining the LLC, which actually, when it comes to piercing the corporate veil, which is the whole point of asset protection, you don't want to do that. Most of the problems that involve piercing the corporate veil have something to do with maintenance. So the cost is actually really critical there. Now, this conversation is quite dense. We cover a lot of ground, but just keep in mind, when you hear something about asset protection, it may not sound very sexy, but if something goes wrong, the way that these documents are written, the way that these entities are maintained, it can be the difference between you keeping your entire fortune or being completely wiped out. Unfortunately, I know many people that have experienced both of these outcomes, and it really all comes down to the concepts that are discussed in the show today. In fact, I really can't help but nerd out a little bit when I have conversations about this. There's just so much to learn out there on this topic, and it can be really critical. Of course, you don't want to get too bogged down in layers and layers and layers of entities, but there are a couple of tips in this podcast that can really help you out. One of the things we talk about in the episode is that probate is extremely expensive, and you can actually avoid this process, or I should say your heirs can avoid this process by putting a document in place that probably costs about $2,500 to draft. So it's definitely worth a listen. We're going to talk about a lot of things, charging orders, living trusts, etc. But like you probably expect, we cover a ton of ground in a short amount of time. I'm sure you're going to enjoy it. Also, if you're a relatively new listener to the show, welcome aboard. Very glad to have you. If you have heard a couple episodes, gotten a few takeaways, and haven't yet left a review in iTunes, make sure to do so. Literally, every single review makes a big difference in the show's visibility because of iTunes' algorithm. We currently have about 93 reviews, so we're just 7 away from hitting the big 100, which will be a pretty cool milestone. It's definitely something that I have been looking forward to since we originally launched the podcast about a year ago. People are always looking for a way to do something generous, but they always want an easy way out. Well, guess what? This is one of those ways out. You can actually do it right now. It takes less than 2 minutes. Go to the iTunes podcast app, search for the Cashflow Connections podcast, leave a short, honest review, and that's it. Of course, if you do, just send me a screenshot to info@cashflowconnections.com, and I'll make sure you have our commercial real estate due diligence ebook for free directly to your email address, instant download. All right, hope you enjoyed the episode. How's it going, everyone? Our guest for today is Garrett Sutton, who is a nationally acclaimed corporate attorney and asset protection expert who has written a number of books guiding entrepreneurs and investors. Garrett's bestsellers include Start Your Own Corporation and Loopholes for Real Estate, among many others, in Robert Kiyosaki's Rich Dad Advisor series. Garrett is the founder of Corporate Direct and Sutton Law Center, which since 1988 has provided affordable asset protection and corporate formation and maintenance service for investors around the world. He's the graduate of University of California at Berkeley and Hastings College of Law. Garrett, I gotta say, I think in early 2009, late 2009, early 2010, I was exposed to your book, and I have been a big fan of yours since that time. So it's really an honor to have you on. Thanks again.
Well, thank you, Hunter, for having me on the show. It's really a pleasure to be here.
So we have a ton to talk about today, and I want to pick your brain about this topic because it's obviously something that's really important. It becomes more and more important as your situation starts to be more complicated. You start to see some success in real estate, etc. But I got to ask a question regarding Robert Kiyosaki. How did you originally, get connected with him? How did you guys start working together?
Well, a friend of mine from Reno, a CPA, moved to Arizona and became acquainted with Robert. And Robert was putting together the advisor group and really wanted a Nevada attorney on the team. And this lady was nice enough to recommend me. And I met with Robert, and we kind of bonded because we both played rugby over the years. So we just have since then traveled the world talking about financial education. I was just in Australia a few weeks ago with Robert and a few of the other Rich Dad advisors. So it's been a great relationship, and we've really traveled the world, not only the United States, Hunter, but around the world, talking about financial education and improving your financial situation.
Yeah, it's pretty remarkable. I mean, I can't tell you how many experts, entrepreneurs, investors, just influential people that I've had the opportunity to interview on this program. And obviously, Robert's name comes up, I mean, probably 70 or 80% of the time. That was like the single most important and most influential person in their own career in terms of making them think about money and finances in a different way that motivated them to take action or make a change in their life. It's remarkable. And, I want to thank you for your efforts in that as well, because I know that you've been a big part of that team. So, again, really looking forward to this conversation, which we're going to focus on asset protection today. I know that you have a background talking about a lot of different things, but before we get into some of the weeds, from your perspective, why is this conversation so important? Why is it important to focus on asset protection and not just the top line only, so to speak?
Well, we live in a very litigious society. Americans sue each other more than any other country on earth. And there are more lawyers per capita in the United States than anywhere else on earth. And, the system rewards attorneys for bringing cases against people. The attorneys receive a contingency fee. If they succeed, they get a percentage of what is collected. So the system rewards litigation. And you and I aren't going to change that anytime soon, Hunter. So we have to take steps that the law allows for us to protect ourselves. And so right at the start, as you start your business, as you invest in real estate, you need to know that these entities, corporations and LLCs and limited partnerships are available for you to use so that you can invest and start a business with some limited liability protection. And so asset protection is really important because we live in this litigious society. And, they don't teach this in school. I wish they did, but they don't teach this anywhere. So you have to gain this information yourself. You have to listen to shows like this where you will learn about this because it's not part of the school curriculum, certainly.
Yeah, I mean, pretty much all the skills that are anything close to being valuable that I learned, I did not learn in school. I mean, that's not a surprise to anyone listening to this program. Right before we actually started recording, you said something to me that I had not heard before that I found unbelievably remarkable. I was wondering if you could just kind of share that data point with me and the listeners, just so we can have an understanding of how exactly litigious and how important this conversation really is.
Well, Hunter, we were talking about the piercing the corporate veil issue, and that comes up when you have formed a corporation, for example, and there's a lawsuit brought against the corporation. The corporation doesn't have any money in it. You tell the person suing that, hey, we don't have any money. And the person looks into your corporate records and finds that you didn't do the minutes, you didn't maybe pay the fees to the state, you haven't filed separate tax returns. And by failing to follow these simple steps, which are called corporate formalities, and which also apply to LLCs, by failing to follow these simple steps, the person who has sued the corporation can go back to court and say, Your Honor, they didn't follow these corporate formalities. They didn't act like a corporation or LLC should, and we want to pierce the corporate veil. In other words, go through that corporate protection that we set up to begin with. We want to go through there and reach the shareholders' personal assets. That's what piercing the veil is, going past the corporation to the shareholder and reaching the personal assets. Now, the data point that you found interesting, and a lot of people do, Hunter, is that this is successful 50% of the time. Half of all cases where they attempt to pierce the corporate veil succeed. And that just means a lot of people are not following these important corporate formalities. They're simple to follow. It's not hard to follow them, But if you don't follow them, the results are pretty darn dramatic.
Yeah, that is remarkable. And I would not have guessed it's anywhere near that. Is there anything that you can take away from some of that data that suggests that people should go one way or the other? For example, I know that S Corps have a little bit more requirements or significantly more requirements in terms of the corporate formalities versus LLCs. Was there any other takeaways that you got from looking at that data that says about 50% of the time attorneys are successful in piercing that veil?
Well, the other thing to know, Hunter, is when LLCs started up, and it's in the late 1980s in Wyoming, so they're a fairly new entity. When they started up, people were wondering, can you pierce the LLC veil? And we didn't have any guidance on that. But now that these court cases have come out, especially since the financial collapse in '07 and '08, a lot of court cases involving LLCs have come forward. And the courts now say, yes, you can pierce the LLC veil, just like you can pierce the corporate veil. So people need to realize that, a lot of promoters say, oh, the LLCs are so flexible, you don't need to have meetings, you don't need to do this or that. When the courts get in there and look at things, you really do need to have the meetings. You really do need to have an operating agreement. So that's the big takeaway, I would say, Hunter, in the last 10 years. Is LLCs are treated like corporations for purposes of piercing the corporate veil.
Yep. Okay. Well, that makes a lot of sense. And I think it's very much on a scale of things. Like, for example, if you are basically a solopreneur and you have a few LLCs, those certainly need to have operating agreements, especially. I mean, that is a literal formality. It can be a simple operating agreement, especially if it's just you that owns that LLC, et cetera. And we'll get into some of the challenges with those single member LLCs in a moment. But there's levels to this game, like there is everything. So, for example, if you're getting information from a podcast, that may be appropriate for, a certain level. But as you continue to grow as a business, you may need to bring someone on that all they do is help you stay in compliance, right? And that's something that we all kind of want to go towards. You can think about some of the largest companies in the world. They have teams of people that all they do is constantly make sure they're in compliance to avoid these types of challenges. So, really fascinating. One of the things that comes up in some of these conversations is kind of the debate between a couple different states when it comes to LLCs and which state is more advantageous. I was wondering if you could share with us some of your thoughts on what states are kind of leading that right now and why you like each of those.
Well, the three main states, Hunter, are Nevada, Delaware, and Wyoming. And we like all three states, but we like Wyoming the best. Delaware doesn't put your name on the internet. It has good good charging order protection, but the annual fee is $300 a year. Nevada, the fee is $350 a year, and they do list your name on the state website, so that's not great. Wyoming is only $52 a year, and they don't list your name on the internet, so you have privacy there. And so, just based on the cost and the anonymity, we like the Wyoming LLC best. And a lot of our clients, when given that choice, are forming in Wyoming.
Interesting. Now, you mentioned a term that is obviously critical when it comes to asset protection, which is the charging order. Can you explain what that is and why that's particularly related to the Wyoming setup?
Well, the charging order is the remedy for someone suing the LLC from the outside. So we need to distinguish between the inside attack and the outside attack. So let's say you have an LLC and a tenant falls on the property. They are renting from the LLC. They have a claim against the LLC. They can get what's inside the LLC on a judgment. Let's say the insurance doesn't cover you. That tenant can sue the LLC and get the equity inside that LLC above any insurance payments. So that's the rule in all 50 states. All right. So the charging order doesn't even apply there. The charging order applies when you get in a car wreck. So the person that you injured in the car wreck has a judgment against you. And hopefully you have enough insurance. We always recommend people have an umbrella policy of insurance above their homeowners and car insurance. But let's say it's a really horrific case and the insurance doesn't cover the full amount, and the attorney decides to go after the interest in the LLC. A state with a strong charging order procedure would say to the car wreck victim, look, you can't go in and force a sale of the assets inside that LLC. We're going to give you instead a charging order, which is really a lien on distributions. So instead of being able to go in and force a sale of the duplex, like they can in California and a couple other states, Wyoming, Nevada, and Delaware will say, you're just limited to the charging order. You're limited to receiving what the owner would receive. If they receive a distribution of $10,000, you as the car wreck victim with the charging order will get that $10,000. But here's the issue, Hunter. It's really a pain for attorneys to have to do that. In many cases, the way we structure it, they would actually have to go to Wyoming, hire a Wyoming attorney to pursue this. And by having enough umbrella insurance, the car wreck victim hopefully is going to be compensated with the insurance. The attorney bringing the case is on a contingency, so he gets a percentage of what's collected. He gets a percentage of that umbrella coverage, the insurance money, and they know how to get at the insurance money, but they're not good at getting at the Wyoming LLC interests. And so when they have a choice of taking another case with insurance monies or having to hire an attorney in Wyoming and monitor the distributions from this LLC, which do they choose? They choose the least path of resistance, which would be the next case. So that's how we structure things. We make sure our clients have plenty of insurance in case there's a really bad accident, and then have their entities owned by Wyoming LLCs, which gives the charging order protection.
Okay, interesting. And so thanks for clarifying that, because of the charging order is something that a lot of people aren't taking seriously, but it is, at the end of the day, it's pretty much the determining factor in how things are going to play out if you do have some kind of challenge. So it's definitely something to take note of. Now, when you mentioned the Wyoming LLCs, and most of the deals that we've created and almost all the deals that I've invested in, and we typically invest in passive LLCs or LPs, GP LP situation, and my company will invest in the LP and we'll create our own entity for a variety of reasons. But we usually use Delaware LLCs. Typically, the Delaware LLC is the owner of a property that may or may not be in Delaware, usually not in Delaware. But is there any reason that you can think of that it's more common in the world of syndications to use the Delaware LLC? At least from my perspective, I've reviewed hundreds and hundreds of deals. I'm currently an investor in about 30 syndications. I'd probably say that 80 to 90% are Delaware LLCs. Is there anything related to the specific GP LP thing that would make that more advantageous, or what are your thoughts on that?
Well, the Delaware LLC is a good entity, but let's say you have a syndication in Texas. You would have to have the Delaware LLC qualify to do business in the state of Texas. It's not hard to do, but you are collecting rents in Texas. So the Delaware LLC has to be qualified to do business in Texas. So whether you use an LLC or an LP, they each have their own advantages. For syndications, I kind of like the limited partnership, because then, Hunter, you would be the general partner through perhaps a Delaware LLC or another entity. And under LP law, with as little as 2% general partnership ownership, you have absolute control of the investment. And so for syndications, the LP structure can work.
Okay.
Does that answer the question?
Yeah. So actually, I want to clarify, because just for my own learning. So typically the way that our deals are structured, we have a Delaware LLC that is in a GP LP structure.
Okay.
And the GP may be another Delaware LLC. When our investors invest into one of our offerings, they invest into the LP of this Delaware LLC. Is that aligned with what you were just describing, or are you talking about a different type of entity, like a limited partnership entity?
Yeah, you could do it either way. The key is that the Delaware LLC that your investors are investing in is qualified to do business in the state where the property is located.
Got it.
That would be one addition that I would add.
Got it. And something else that comes up regarding, not even just doing business in the state that you're doing business in, but also we have invested in assets all over the US, but they are managed to a certain extent. And I know that lawyers have different opinions on what, quote, managed means. But because the offices of Cashflow Connections were located in California, we are registered in the state of California. And so that means that we pay the additional $800 fee. So our setup typically is we have a Delaware LLC where we do pay that $300 a year. And it's registered in California, so we pay the additional $800 a year. Is that something that is typical with some of your clients? Is that something that you are an advocate of? And I know that California is very unique, but just wanted to get your thoughts on that structure as a whole.
Well, California is really aggressive about collecting their $800 fees. So yes, having the Delaware LLC qualified in California is something you have to do. If you don't pay the $800, the fine in total is $12,000. One strategy that we use with our clients, Hunter, would be, let's say you have a syndication in Florida, Texas, and Utah. And we have a Delaware LLC for those, or a Utah, Florida, Texas LLC for those. We would then have those interests be held by a Delaware LLC qualified in California, so that we would only have to qualify the holding entity the one time in California, instead of having to pay the $800 three times for Utah, Florida, and Texas. We would just pay it one time for the holding entity that held those three other LLCs. I know that's somewhat complicated, but that's how we've been structuring things for the state of California.
Okay, that makes sense. And the listeners will be able to follow along, because really, especially if you have a fund, let's say, that has properties all over the country,
right,
you wouldn't want each of those properties to have to be registered in the state of California. You would have all of those properties be owned by one LLC, which is registered in the state of California. That's kind of the summary of what you just said there. Is that correct?
Yeah, you would have the Utah LLC, Florida LLC, and Texas LLC be, they're in the states where the property is located. Those interests would be held by a Delaware LLC qualified to do business in California, because that's where you're located.
Got it.
So that's how we would structure it.
Okay, perfect. And thanks for the additional clarification there. So one of the benefits of investing in syndications is that the investors, the LP investors, are extremely limited, if not completely limited, from things like liability, from challenges that may arise on the property, or things like credit.
Right.
But we do see a lot of investors, because of that, a lot of our investors invest in our funds via their own personal name. Now, I think that they are well protected, from my perspective at least. They're well protected for anything that may take place on one of our properties. But could you give us an idea as to why that may not be advantageous for other reasons in terms of asset protection?
Well, on the inside attack where the tenant sues, you're right. Your investors are protected. They're not going to be held liable in that case. On an outside attack, the car wreck, if they hold title to your LP or LLC in their individual name, someone could try and reach that, but it's in an LLC or an LP. It's going to be difficult for the attorney to get at that. However, some of my clients who do investment or syndication investments would have a Wyoming LLC that would invest in all their syndications. Thus, if they get in that car wreck, instead of, going after the interest in their individual name, the car wreck victim would have to go after the Wyoming LLC with the good charging order protection. So that would be one additional layer I would consider. Not everybody does that. They feel protected as they are. And, my goal is not to set up 17 different layers of protection. You only need 2 at the most. So that would be something that would be a judgment call on your investor's basis.
Okay. And just going back really quickly, because I do want to kind of touch on this, it is your perspective, at least, that investors that are investing in an LP side of things, would you say that their liability is basically eliminated because of the fact that they're investing as a limited partner? Or is that too strong of a word? In terms of the actual on-property challenges?
Yeah, the on-property challenge, the inside attack where the tenant sues, whether your interest is held in your individual name or a Wyoming LLC, you're still protected, right? Because that's an obligation of the entity, not the individual owners. Again, the car wreck example where someone's coming after you because of a claim that arose outside of the real estate holding.
Right, from your personal action.
Right? It's not a tenant that's suing, it's a car wreck victim that's suing. They could reach your individual interest in that LP or LLC. They wouldn't have management control or anything, but they could reach that interest. With the Wyoming LLC, they may have just a better level of protection because of that charging order protection.
Okay, perfect. That is aligned with my thinking, but it's always good to clarify because there's always can be misconceptions out there in different people's opinion. So let's talk about trusts. I'm a huge proponent of trust. There's a variety of different trusts and different structures. Let's start with living trusts. What are these for and what are these not for, I should say?
Well, let's start with they're not for. Plenty of promoters say that they provide asset protection and they don't. The living trust provides zero asset protection. However, they're good for avoiding probate. If you have a will or die without a will, your estate has to be handled by the probate court in the county in which you passed. And that is expensive, it's time consuming. So the living trust avoids all of that. The living trust says we've set up a trust for the distribution of assets, and we're going to do this outside of the court system. And it is a huge money saver for people to have a living trust that can distribute the assets outside of the court system. The attorneys make out really well in probate. And so spending $2,000 for a living trust will save, $20,000 or more in going through probate. So that's the benefit. And so, Hunter, they work together. The LLC will provide the asset protection on the real estate that you own or the businesses. Then that LLC is owned by your living trust, which provides the probate avoidance. So they both are important. We just need to appreciate that one provides asset protection, the LLC, the other provides probate avoidance, the living trust.
Yes, and this is something that has come up recently a couple of times, and I want to clarify so that the listeners know. So even if you have a will that is very, very clearly outlined, it is very likely that the court system will have to be involved in the event of your passing. Is that kind of what you just outlined, first of all?
That's correct. If you have a will, it has to go through probate. If you pass without a will, it's called intestate, that has to go through the court system. But by having the living trust, you avoid the probate court system.
Got it. So this is something that is probably surprising even to a lot of people that are listening to this podcast. Even if you have a will that says this is exactly what I want to happen under no circumstance, there's no conflicting documents, it still has to go through the process of probate, which you just mentioned $20,000 or even more $1,000. I have heard in California, especially if you have a large estate, $100,000 can happen like that.
Easily.
So, and that don't even get into what happens if it's a lack of a will. Just to clarify, what lack of a will means is they basically look at the entire body of what you've got going on in your personal life, and a judge makes a call on how it will be handled. So don't do any of this. We're going to talk in a second about when it makes sense to create a living trust, but try to avoid this because just having a will is not going to make it so that your family doesn't have to go through the probate process. Now, when it comes to economic viability, what number of assets do you think it makes sense to create a living trust? Is it having $100,000, $500,000, $1 million? Where do you think it starts to make sense to create that and then maintain that?
Well, many states will have a dollar amount whereby if you're under, for example, in Nevada, if you're under $20,000 in your estate, there's a summary probate. It's not expensive or time consuming. So above the 20,000, then you have to go through probate. So that would be a good time to consider a living trust. The other issue for me is, Hunter, is not so much the money, but the distribution. How do you want your assets to be distributed? If you don't have a will, the state will decide how to distribute those assets. You may not want it to go that way. The will can provide how your assets are distributed, but people challenge the wills. So I like the living trust It keeps you out of the court system. The probate is publicly noticed, so people know that where your distributions are going. The living trust gives you the privacy and allows you to make those distributions to family members, charities, and others with more certainty.
Yep. And it's actually interesting because this is coming up in my own life. As many of the listeners know, I just recently got engaged. And so
congratulations.
Thank you. And, you can probably imagine being engaged to me. That living trust document is not quite signed yet, but we're in the process of doing it because I don't want to have to go through any of this process.
Right.
And I don't want anyone involved to have to deal with it either. So that's a pretty interesting kind of story there. And I actually didn't really fully grasp the implications of probate and thinking, here I have a will, so that everything's solved. Not the case. Going to asset protection, kind of looking at in a different angle, for many, many people, the single largest asset that they're going to own is their own personal residence. Is there a way to mitigate the challenges that arise from owning their personal residence in their own name? And do you suggest that people do that? Is there a way to get around owning your personal residence in their own name without losing, the ability of access to debt financing, for example?
Right. Well, the first way, Hunter, to look at protecting your personal residence is with what's called the homestead exemption. And it started in Texas when they were an independent republic. They wanted Americans to move down there. And they said, look, we are going to create this procedure whereby if someone sues you later, they can't get at the equity in your house. And it worked like a charm. It attracted settlers and other states followed. And so, for example, Texas and Florida, if you get sued, they can't get the equity in your house, even if it's worth $5 or $10 million. That's why OJ moved to Florida. So the states have different dollar amounts. So, for example, Texas, while being unlimited, and Florida's unlimited, Nevada's is $550,000. So here's how it works. If you have $1 million house with a $450,000 first deed of trust against it, you've got $550,000 in equity. By filling out this simple form that you can get at Office Depot and filing it with the county and paying a $20 filing fee, in Nevada, that $550,000 of equity is reserved for you as against a later creditor. So the homestead is a great way to go. California, if you're married, it's only $100,000 you can protect. And so, most homes are worth $1 million or more in California now. So it may not be the best way to go. Certainly having the umbrella insurance is a good idea. Some of my clients will put their personal residence into an LLC. It's not always the best way to go. Debt is a form of asset protection. You could take out a second deed of trust, a HELOC, to further encumber your personal residence. So there are various strategies, but I would encourage your listeners, Hunter, to look first at the homestead exemption. And on our website, we have a list of all the states and the homestead exemption amounts. So if you go to Corporate Direct, you can find the homestead list.
Yeah, that's fascinating. We could actually probably do an entire podcast episode on just a couple of those data points in terms of owning your own personal home in an LLC or, encumbering the home. Just a quick summary is basically saying, look, you cannot come and strip equity from this home because I have now borrowed more money from it and someone else owns it and you can't take money from them. Is that kind of the brief summary of what you mean by, yeah, okay,
right,
got it. So there is something that I have heard come up a lot recently that I really would like your opinion on, which is the series LLCs and their applicability, their functionality. What are your thoughts on the series LLCs, and are you an advocate of kind of implementing those in some capacity for investors or syndicators, et cetera?
Well, I'm not a fan of the series LLC, in part because there are just too many unknown. I want to put my clients into something that has certainty. The series LLC is only approved in 18 or 19 states now. So you set up a series LLC in Delaware and you bring it into a state that doesn't have the series LLC, and you have problems. In fact, there was a court case in Louisiana called Arch Bay Holdings where they used a series LLC in Louisiana, and the judges were just totally confused by this thing. So it wasn't a good outcome. The other thing is, how many cases have there been out there defining the series LLC? There are just not many cases. And two other points, Hunter. We don't know what happens in a bankruptcy. If you have one series, the series LLC, you set up one series LLC, and then you have different buckets or series that you put the real estate in. So you've got a duplex in one series and a fourplex in the other. If you go bankrupt on the duplex property, we don't know what happens to the fourplex property, right? We just don't know. There's no case law. There's no understanding of that. And so I'd rather have my clients in two separate LLCs where we know exactly what happens in that case. As well, in California, there were promoters that said, look, in California, it's $800 per entity. Let's set up the series LLC and pay the $800 for the series LLC, and then have 10 separate series or buckets. You put 10 properties in it. Well, the state of California, at least they're consistent. They said, we're going to charge you $800 per series. So instead of $800 once, the client had to pay $800 times 10. So we just have to be aware of the unknowns of the series LLCs. That said, I think, maybe in 10 years, all 50 states will have them. There'll be a consistent law involving series LLCs. So, it may be a good thing in the future. But right now, for me, with all the unknowns, I'd rather just have my clients set up separate LLCs.
Got it. And I appreciate that. It's interesting because I have heard someone talking about it, and actually they're coming on the show soon to kind of discuss their perspective on it. And, for those of you listening at home, I am, in Cashflow Connections is the manager of 14, 15, 16 LLCs. So being able to limit the amount of times we're paying that $800 a month is very significant. So I'm looking forward to the case law. I'm also looking for the conversation. Actually, I should ask you, what would be some of the questions that I should ask, or a question that I should ask the guest that's coming on that's a proponent of the series LLCs in terms of, how to get to the bottom of some of your, potential challenges with that structure?
Well, I would ask him how many states have approved it and how many states haven't. I would ask him about the Arch Bay Holdings case in Louisiana. I would ask him about the bankruptcy issue. And certainly California's attitude towards series LLCs. You're not gaining anything, but you're not saving the $800 by using the series LLC. So, every attorney has a different perspective. I'm not saying mine is absolutely 100% correct, but in terms of how I like to deal with my clients, I just don't like to engage in these newfangled entities that aren't proven in court. So that's just my take on it.
Totally. Yeah, and I appreciate that as well. And it's interesting for you guys that are kind of going through this process for the first time or looking at legal documents. Many cases, they will leave the terminology somewhat vague so that no one really knows. It leaves the litigators the flexibility to kind of make it up as they go along. And that's really how a lot of this case law is created, is one case law creates something, they use that case law for something else. And so it hasn't been solidified yet. Something that we deal with a lot in real estate is the fact that you don't have to have a lot of employees, you don't have to have a lot of partners to accomplish some pretty remarkable things in the industry. And because of that, there are a lot of people with single member LLCs. But there's some challenges with that structure, at least some potential challenges. So walk us through what some potential challenges would be with having and maintaining a single member LLC, particularly as it relates to asset protection.
Well, this is a big issue, Hunter. In many states, the single member LLC is not protected. And when you look at the charging order protection, really it's to protect the other partner. The charging order says you can't go in and force a sale of the company, in part because you've got an innocent partner who didn't get in the car wreck. So why should you be able to sell the company and harm the innocent partner who didn't get in the accident? So that's one of the theories behind the charging order. Well, when you have a single member, there's no innocent partner to protect, right? And the courts are looking at this and going, well, why shouldn't the car wreck victim get a charging order or be able to force a sale of the LLC interest? They're the one that got in the accident. There's no innocent partner to protect. So a number of courts, California, Utah, New York, Georgia, a number of them do not support the single member LLC. Just for that reason, there's no asset protection because there's no innocent partner to protect. Now, that said, Hunter, Other states that compete for formations, like Nevada, Wyoming, and Delaware, say, look, we want to protect the single member LLC. We want to give people the asset protection, even if they're a single member LLC. So there are states that will allow the single member LLC the charging order protection. So it's important when you're setting up entities, if you are a single member, to set up in the right state. As well, you need the right operating agreement. We have a single member operating agreement. Too many of the promoters out there don't recognize that you need a different operating agreement if you're a single member LLC. But it can be done. You just have to pick the right state.
So would you say that a Delaware LLC that's a single member LLC with done correctly in the right operating agreement that is registered in California, would that be counted as a Delaware LLC or would that be counted as a California LLC?
Well, that's a good question because we don't have case law on that. We don't know, would California law apply or would Delaware law apply? Now, what we do for our Wyoming clients is the LLC interest is considered personal property. And a good attorney in California is going to say, look, you live in California, you have that certificate with you in California, California law applies. What we do is we take delivery of the certificate up in Wyoming and we hold it in a Wyoming safe deposit box. And if the claim arises, should Wyoming law apply or California law apply, the attorney, we're going to hold that certificate in Wyoming. To gain that asset, they would have to seize the certificate in Wyoming. They would have to go to court in Wyoming to get that certificate. And by that point, Wyoming law applies. So we call it Armor 8. It's based on Uniform Commercial Code, Section 8. And, for $75 a year, we hold the certificates for you up in Wyoming.
It's pretty remarkable. And I mean, we could go on and on back and forth about this, but it does sound like we've covered a tremendous amount of ground. There's just so many topics. There's so many avenues when it comes to asset protection because, again, there's levels. I mean, we haven't even gotten into the whole international thing, which I don't even know if you're a proponent of that. I don't know if you've used that before. There's just so much available in the U.S. that is very, very solid. So, I definitely want to be respectful of your time. But before we jump off, I definitely want to give you the opportunity to, share your firm, how they can learn more about you and your company.
Well, thank you, Hunter. The main website for us is corporatedirect.com. We have a lot of information there. If you want to find out about setting up a corporation or an LLC, you can call the office. The paralegals provide a 15-minute free consult, so you can talk to someone. The number is 800-600-1760. We charge a very affordable fee. It's $695 for the complete package. And then the filing fees vary from state to state. So we make it affordable. Then we also want to make sure, like we talked about piercing the corporate veil, that you maintain your entity. And so we will assist you over the years to maintain that entity so you stay protected. So, that's our focus, is setting up entities and maintaining them at corporatedirect.com.
Awesome. Well, Garrett, again, it's an honor to have this discussion, and we'll leave that information in the show notes page. Thanks again for coming on the program.
Thank you, Hunter. It's been a pleasure.
All right, listeners, thanks for checking out the episode. As always, the contact information for our guest will be available in the show notes page, which is hosted on SoundCloud, iTunes, and Stitcher. Don't forget, if you want access to some of the free goodies that I'm talking about at the beginning of these episodes, like free ebooks, weekly investor emails, and articles about some of the most important investment-related topics, make sure that you have created an account with CFC because this stuff is automatically available. You can do this by going to cashflowconnections.com and signing up as an accredited investor. Of course, if you have any questions, feel free to email me at hunterthompson@cashflowconnections.com. Thanks again.